Hello, everybody, and welcome to the next in our series with the NC LEAP Lawyers Entrepreneurs Assistance Program. We are so glad to welcome Tristan Hunkin to present with us today. Tristan is a lawyer with Hunkin Law Firm, and she does a lot of work with entrepreneurs, business owners on a range of issues and needs. Today, she's going to be sharing with us about protecting your business legacy, looking ahead to possible wrapping up dissolution, and what you need to have in mind now in order to protect yourself and your business looking forward towards its end if you find yourself in that spot. Tristan will be presenting a PowerPoint presentation, and we will make that presentation available on our website. I will put the website into the chat box. We will also have a recording of this presentation available on our website for you to access at any time. Thank you for being here, Tristan. We're really grateful to have you.
Yes, thank you so much, Kim. So as she said, I'm an attorney in North Carolina. I operate a virtual law firm called Hunkin Law. So we actually do this quite often. This is the way we communicate and jump on Zoom. And today I want to share with you about protecting your business legacy. And a lot of that should happen, as Kim mentioned, now versus later so that you can be prepared ahead of time. So some of the things that we'll address today is proper dissolution. That is, if you are planning to go ahead and dissolve your business, there's a specific way North Carolina requires you to do that. Buy and sell agreements, if you are not a solo owner, if you have a co-owner or anyone who has done interest in your business, then you'll want to identify if a buy-sell agreement would be important for you. Basic business estate planning, and that is just preparing for if you're going to retire, if you're going to work your business till you die. What is the plan for the end of the business for estate planning? And then succession planning. It's very similar to business planning, but it can happen long before death or incapacitation. And so we'll want to discuss that. I do want to share two things. One is that this topic of business planning for succession, dissolution, or estate planning, that it's huge, it's monstrous, and it can be very detailed depending on what your business is. The type of operation. So if you're an LLC, a corporation, if you're a solo practitioner, there are so many different avenues that your business could go down, legally speaking, that are specific to who you are and how you operate as a business. So what I'm going to provide today is a general overhead. There are whole classes that go months on end discussing this topic. So this will hopefully get you in the right direction, get you exposed to the information, but please know it is in no means exhaustive of what you're going to need to do specifically to your business. And then the other thing is, again, this is education. No one has hired me as an attorney, so this is all I'm providing is education. And it should certainly be treated as such. If you have additional questions, certainly seek out advisement by an attorney or business professional. All right. So as a life of a business, there's lots of different stages. Right here, I just listed 4, but if you are actively in your business, you know there's about 2,000 more steps. Some of them don't go linear either. They go backwards and forwards. But in the grand scheme of things, things are formally operating. So you've registered, you have a business name, you have the cards, you're putting yourself out into the world as a business owner. You have a business bank account, the whole thing, you're formally operating. Then you go through some foundational growth, you're doing things right, you're making some good decisions. You might choose to expand, you might choose to maintain that growth without any elaborate expansion. And then comes to the end stage, which is your transition or your dissolution. And we'll talk about what the difference of those two mean. But basically it's saying, right when you start a business, you should have the end in mind. A lot of business owners talk about having the end in mind. It's a very strategic and wise thing to do, even though it seems counterintuitive. You know, you're excited about starting your business. The last thing you want to think about is ending it or giving it to someone else. But if you do that, then you'll be able to make more strategic decisions about how you operate the business during its lifetime, if you understand how you want it to end. And just know that the decision you make today doesn't have to be permanent on what the ending is. Maybe in 3 years, it grows in a way that you would maybe work it till you die. Maybe you do want to hang on to it, you don't want to sell it. Or maybe it's exhausting to operate and 5 years goes by, it's worth a good penny. And you think, you know what, I think I'm ready to sell. I think this would be a sellable business to move on. So it doesn't have to be permanent, but some decisions are better to at least be made. Having that in the back of your mind of a goal of what you're working towards, what your plan is, gives you direction for your business and makes much smarter strategic decisions as you move towards that goal. So if you're planning for proper dissolution, this information came directly copy and paste from the Secretary of State website for North Carolina. They provided exactly what you needed to do depending on your scenario. So we won't read everything, but you can go on their website. It's linked in this slide. And you can find the mailing address, the current filing fees. I want to say they were like $25, $35. It's very minimal to go ahead and properly dissolve your business. And you do need to do that. If you can't just decide, if you have registered as a business, say you're an LLC, you've registered with the state, that you just no longer are going to operate, but you don't inform the state. That can cause a lot of other fees, taxation problems, auditing. So you just want to make sure that you are taking care of all the paperwork and wrapping up correctly. So if you want to close down, you'll have to voluntarily file what's called an Articles of Dissolution, and that's for corporations, nonprofits, LLCs. Once you have voluntarily dissolved and you filed that paper of dissolution, then you can start winding up your affairs. I always like saying winding down. It seems strange to wind up, but it basically means anything that is lingering. If you have extended contracts that aren't quite done yet, even though you filed your paperwork, if you have a payroll that needs to be reconciled, anything that you need to complete to finish the business, to bring it to a complete close, that is what winding up the affairs of the company means. If something comes along, a big fish, this huge client opportunity, and you've already submitted your articles of dissolution, you can make a choice. You can certainly pass that big fish on, that big client, on to someone else and continue on your path of you're done with the company. Or if you've changed your mind, you can file within 120 days a voluntary revocation of dissolution. So just saying, nope, never mind, I'm going to stay in business a little bit longer, and you can most certainly take on that client or whatever the project may have come your way. Cancellation of partnership, that is for obviously if you are a registered partnership. So that would be an LLP traditionally. And you would file a cancellation of that partnership to the Secretary of State for North Carolina. If you're a general partnership and you are not registered as anything, because you wouldn't register as a general partnership with North Carolina, then nothing needs to be done because there's no entity, there's no formality for you to cancel. That is something that you've done independent. The only thing you do need to be aware of is if you have had contracts between you and your partner that you both have any type of a responsibility to. So again, if you have a lease agreement and you're leasing a space, you can't just walk away. You have to make sure all of that equally gets taken care of together. If you decide to withdraw of a business from North Carolina, so what that means is you are a business owner, maybe in South Carolina, maybe you're on the border, and you started doing business in North Carolina, and you got what was called authority, a certificate of authority to transact. So you're able to do transactions in North Carolina, but you're not registered there. You're registered in South Carolina. If you've decided, no, I'm no longer going to pursue businesses in North Carolina, I'm going to strictly stick in these other states or outside of North Carolina, then you'll need to file basically a withdrawal of saying, I no longer need authority to do that. And so you'll let them know. Again, it's really important that if you have paperwork on the books with the Secretary of State, that you are constantly following up annually to make sure that you are of record and it is up to date. And then if you make any decisions like these that we've talked about of cancellation or dissolution or withdrawal, that you properly follow those procedures to avoid any type of fees or fines or any trouble paperwork wise that your company doesn't need to be dealing with. So that's proper dissolution. And that's when you have made a decision. Nothing's dramatic. Nothing's happened all of a sudden. You're making the decision. So for buy and sell agreements, this is when you have more than one co-owner, and it doesn't have to be equal membership. You can have fronted all the money for the company, and another person comes in and they maybe have 25% interest in the business because they brought the idea. Whatever it is your agreement may be, it doesn't have to be 50-50, but if anybody else has a stake in the company at all whatsoever, can have a claim, then a buy-sell agreement can be very advantageous to protect both of you. Or if there's even more than just two, any number of owners. So the agreement is there basically to see if anything goes wrong, what should you do? A lot of people call this the business prenup. It's when you go into business to people and before something goes wrong, you've decided how to handle the assets that they have brought or any type of financial contributions they've made, and how that can be dealt with if something goes wrong. Most often you have the 5 Ds, which is a triggering event that activates to create the buyout of the leaving member. So that might occur by death of a leaving member. The member might be leaving because of disability. They can't do the job anymore. It might be divorce. It might be departure, meaning they've retired or they've been terminated. Something went wrong, and you don't want to work with them anymore, legally wise. Or it's dissolution. They've decided that they would like to dissolve the business, and perhaps you as the co-owner want to continue forward. So you'd have to re-register as something different than an LLP, for example. So each partner oftentimes takes out life insurance on the other partners, and that's their form of funding that would trigger upon any one of those 5 events happening, so that they could pay out anyone who could claim interest in that person. So if it was death or disability, any heirs that would say we have a right to the interest that my relative had in this business, then the partner that is remaining, the active partner, can use that life insurance payment and pay those heirs. Or even if it's just departure, they've decided to retire, then the leaving member can be paid out by that life insurance. Sometimes you can get bank loans, if not life insurance, but those can be trickier to deal with. It's actually fairly commonplace that life insurance is what's used on the other partner. This is, again, what funds the buyout of the exiting member. So it's just beneficial to have this in place so that when something does inevitably go wrong, no one's feeling cheated. Everybody's contributing to build this business. And if something goes wrong and someone has to leave the business, it's best to make sure that they get some type of fair share value for the work, the financial money they put forward, whatever it was. And you can negotiate that all different kinds of ways. It doesn't have to be dollar to dollar. But that's an important agreement to discuss and go ahead and have those conversations now. Some people really avoid it because they are afraid that it's going to dampen their relationship with their partners or put a stall on the business. But if you struggle with that type of conversation, I assure you, you are going to have a number of other conflicts when clients want to do one thing one way or another. And so it's just good. It's good to go ahead and have that professional conversation. It's a very courteous one to make sure that you guys are equally taking care of one another. No one's going to get something that the other one doesn't deserve. Everyone's covered. So those are buy-sell agreements. Now, this is death or incapacitation for business estate planning. This doesn't necessarily mean if you're partnered, it could be anyone. You could have multiple partners. You could be a solo solo owner, whether you're running an LLC as a solo or you have a sole proprietorship. This is just business estate planning to cover any of those scenarios. So if you don't have any planning right now, if you were to drop dead right in this minute, or become incapacitated, you get in a car accident, something tragic, what would happen to your business? And just take a minute to think, what do you think would happen? Who would scramble to pick up the pieces? Where would it go? Who would know to call your clients? Who would know to take care of the contracts for the vendors that you have? How would it be taken care of? And if the answer is, I have no idea because I don't have any of that planned out, then you're in a good place, because you definitely want to start learning how you can make those decisions. And you can write a lot of that yourself. You can write out what the plan and the strategy should be. So what happens if you don't? If you stay in this place of, I have no idea what would happen, you have no estate planning in place. If you operate as a sole proprietorship, meaning you're not registered with the state, you're not an LLC, you're not a corporation, you're not a nonprofit, you're not registered, and you die, then the business dies with you. People cannot simply pick up the business after you. It can become very complicated. So sole proprietorships are basically one and the same. They're taxed the same. Their taxes a bit like they are the business. So when that person passes, the business also comes to an end. Under intestate succession laws, which basically intestate's just meaning someone has died without a will. There's no will in place. How do the inheritance get distributed? And in North Carolina, a business that is not a sole proprietorship, so maybe there is a partnership involved, or anything else, an LLC, something like that, it would pass to the closest heir of the owner if they die without a will. And so a lot of times, if the person wants to dissolve it, maybe the spouse, if they're married, doesn't want to run whatever business. I had a trucking company that I just worked with on this very issue. Her spouse knows nothing about the trucking industry. So for it to go to him didn't make any sense. So we had to really make sure that we put something in place, because by North Carolina, that's where it would have gone. And it's a prosperous business. And so for it to simply be sold by its assets and then distributed would leave her children with some money, but not as much as it could if the business kept going and they continued some type of interest in it. So we had to create a better plan for that. One other thing I will add is that if it is sold and it's decided that it just needs to be dismantled, the heirs will, in North Carolina, and I put a link there where it says intestate succession laws, you can go read chapter 29, and it basically just shows you all these different scenarios of if you are married and have children, if you're married but you don't have children, if you're married, have children, and your parents are still alive, if you're all these different scenarios of how it works, because it's not as clean cut in North Carolina as you would think. Your spouse does not get 100% of everything. If you have living parents and you die without a will, they can also have a claim to some of your inheritance. So very unique settings in North Carolina for you to explore and be aware of. And again, that's all in chapter 29, which is linked here in the PowerPoint slide. So as you can tell, this can cause a great deal of drama. A lot of family members who feel like they have the right to something that you had might speak up. It can really hurt relationships by not having this planned out properly. And then obviously it can have a loss of revenue if you're if you're disrupted by any of the distributions you should be making to clients. Any type of vendor agreements that you're supposed to be having can cost you a lot of money to correct those concerns. So with estate planning, if you go ahead and do decide to sit down, decide who is going to run the business upon your death or incapacitation, who will inherit the whole entity, the whole company, or at least shares of the entity. If you have estate planning in place, then you've already named someone. So there's no unnamed person. No uncle can come over, or brother-in-law, and say, I worked a couple jobs with them, so I really do think I could run the company and just take over. That's not the way it would work. You would have them named. If that's who you wanted and you thought the brother-in-law was great, that's a great person, then you can name them in your will as a managing member. But at least you've been able to make that decision. It's not been left up to probate court. It's not been left up to family squabbling and seeing who is the most resilient to deal with all that. You can make those decisions, and that puts so much clear and prepared knowledge for your family. It allows them to spend time doing what they should be doing, which is celebrating your life, grieving the loss that they've just incurred, and being able to honor your legacy that you've built with this business, and how the operations of the business need to either continue as you've deemed, or conclude that you want them to wind down. And you can certainly do that too. You can choose that the business, even if it's an LLC, you can choose that it dies with you. And that's your name. That's your copyrighted name. That's your copyrighted business plans and models and any type of slogans. You can make all those decisions to control what rightfully belongs to you. If you do choose to plan and you do choose to get a will in place, which is very, very smart, most people want to have some control over the time and energy, money, emotions that they've put into building something, then you'll also want to consider a trust. Now, trusts are not always necessary if it is a small business, if there's just not that many assets. But the moment you start developing even, let's say, additional vehicles, for your lawn care company, or additional machinery, or perhaps you have certain real estate that goes with your business, then trust protection can be very advantageous for you, both in protection from creditors as well as certain tax benefits. So when you're alive, you can have what's called a revocable living trust. You can be in complete control of this trust. It does not have to go to a different trustee. You can be all three things: the grantor, the trustee, and the beneficiary. Now, if you operate like that, which a lot of business owners do, then because you're in control of the assets, then you actually do not get those protections from creditors. You can still have some tax benefits for this, but the protection from creditors, still need to pay certain taxes. That will still occur because you have access to the assets. Upon death, you automatically turn from revocable to irrevocable. Once it becomes irrevocable, a secondary successor trustee takes over the trust. And when it becomes irrevocable, then all those assets that you put into the trust are now protected from creditors, any type of certain business taxes that can happen to business assets. You'll be able to avoid those because you're no longer able to access that funds. As long as you have access and control over the assets, then you have the ability to make payments. You have the ability to say where those payments go, and therefore creditors can still be paid. If you don't have access to it, which you can also do while you're alive, you can create an irrevocable trust that you name a trustee, an independent trustee that will oversee your trust, even while you're alive as a business owner. This is much more challenging to do. It can get a little bit more complex because obviously as a business owner, you need to be able to make quite a few decisions, and you need access to some of your revenue. And so what goes into the trust, what doesn't, that one's a little bit more expensive because you really want to hire an independent trustee to make sure the courts truly view it as independent. So just to let you know, it's possible, but it's more complicated. And I would advise you to talk with someone specifically on that if you were trying to control your assets in that way. All right, along with a will and a trust is a power of attorney. So it's definitely, if you don't have a will, just know you definitely, or even if you do have a will, actually, where there's a will, there's a probate. That's what they always say. And so that means with the will, you will definitely go to probate court. If you have a trust, then you can avoid probate. And so that's the other benefit of having a trust that I should have mentioned earlier, because the trust outlines exactly where everything goes. There's an immediate upon death new owner, and so those assets are no longer to be a part of your estate, and so that's how that avoids probate. So, but with those things, you also have a power of attorney, and this is a very, very powerful document, as the name alludes. But POAs give a person the power to make decisions for you. So you choose someone that you trust, that you believe has your best interest and understands the decisions that would be before them. And it can be a limited POA that only triggers upon death or incapacitation. That can go within your trust, it can go within your will, or it can become active prior to those events happening, but for a specific event. So a POA allows a named person to only complete the tasks that you've granted permission such as like buying and selling real estate or making medical decisions. So when my husband and me used to be Coast Guard, and when I got out, he stayed in. His next tour was to deploy on a cutter for several months at a time. And so we were just about to buy our very first home, and he had to get underway during basically a week before we were supposed to close on our home. So we had to do a power of attorney, and I'd sign my name on where I was supposed to sign. And then if anybody signed for a power of attorney, you know, you have to write this long sentence to sign in the power of acting as, and then you sign for that person. And so when I got my power of attorney to operate for my husband for the purchase of that real estate, that was the only permission I was granted. I could not make any other decisions other than that. I couldn't go and turn around and sell that very same real estate because that's not what the power of attorney allowed me to do. And so having had that experience, I've now gotten to see other power of attorneys, having worked at previous law firms, and they're broad. Some of the powers are extremely broad because people have gotten a little bit lackadaisic and they make cookie cutter blanket, everybody signs here, power of attorneys. Just be careful. You can edit anything. So if you find something on the internet that you think is going to work, that's fine. There's nothing wrong with doing that. But it's very important that you read everything and change what doesn't fit. Make sure that it fits what you really need. The power that someone can have to open bank accounts in your name, to make medical decisions, that's huge. So you want to make sure that you are granting the right person, but even the right person can be burdened by temptation, or maybe it's not even temptation. For medical examples, there are people that you would ask to make medical decisions and it's just too emotional. It's too emotional for them to decide because you didn't say if you wanted to be resuscitated or not. That was for them. You just told them they could make all medical decisions. It was really broad. And they know that you don't want to be resuscitated. Maybe it's a religious thing, maybe it's just your own personal opinion, but they can't be the ones to say it. And so you have this person who has this power and they say, nope, keep them alive. They're a vegetable, but keep them alive. It's a decision I've got to make. And so you want to be very mindful that these documents, they're not just little pieces of paper that get stuffed in a desk somewhere and then sometimes become useful. If they're executed correctly and they're crafted to customize to each person's use, which they have to be, there's no one size fits all for any of these. For a will, for a trust, for a power of attorney, there's no one size fits all. So you have to customize it, and that way you're getting the outcome that you want. These pieces of paper are not just documents. They are going to deliver a specific outcome. So take time to ask yourself, what is the outcome that I want? What am I really hoping for to achieve? And then make sure that that power of attorney or that will or that trust, make sure that those documents execute exactly what you want to have happen. So you can have a financial power of attorney, like we alluded to. It can be for estates. It can be for managing any type of accounts that you might have. You can have medical power of attorneys, which again, we alluded to, can be for all kinds of things. Maybe it's they have to amputate, or the surgery or no surgery. All of these things can come with a medical power of attorney. So that one's a little longer. You really have to think through, no, I have no problem giving them broad blanket responsibility, or there are certain things for sure I would want to have a certain way. And so make sure you document that. You can clarify the decisions, assign the individual, and then make sure that they know that they've been assigned. I think that's a really smart thing to do. Some of these power of attorneys don't come to life, like we saw just a minute ago, until you are dead or incapacitated. So another thing to keep in mind is please update. So many people get these things done maybe in their 30s or 40s, and then they don't touch them again. But you may not even be in contact with some of the people that you named in your will or in your power of attorney. Things change and your preferences change and your relationships change. So make sure that, annually, biannually, you're kind of just looking over your documents. Do we need to update? Yes, no, and then act accordingly so that you can be protected and everything can be as peaceful as possible when that moment comes that these documents are really needed for you. So succession planning, it actually is kind of all encompassing of everything we just talked about. It's a broad term that could mean any of the things that we discussed, but it's also has its own specific life to it as well. So I wanted to take a minute and talk about it. It is a detailed plan that your company, usually in their operating agreement, would put into what would happen if you needed to be replaced, whether it was because of death, or maybe it was because you were ready to sell the company, but you wanted to leave behind how they could operate it. Maybe somebody else in the company was moving up, it was ready for you to retire. Whatever the situation, it doesn't always have to be death or incapacitation that occurs. You just want to make sure that your business lives on. You're not ready for it to go. You're building something that you hope outlives you. And so that is what succession planning really promotes and tries to guide business owners in doing. You want to be able to name key personnel. So if you have more than just you want to name those roles and what they would need to take on. So leaving behind any type of operations manuals for those roles can really minimize any interruptions to the business that you might have. There are some hesitations that I'll go ahead and bring up now that you may not have even thought of, but I've had clients come to me very nervous about succession planning because they've grown their business. They do have employees, but they are still the sole owner. It's just them. And they're getting to a point where they'd really like to bring someone on and train them on how to operate the business, not so they can sell it, but so they can step back. And they can still be the owner, but maybe they have an operations manager. Maybe they have like a head honcho that runs everything the way they're running it right now, but they still want to profit from the business, profit from the years of building it up, all that stuff. But they're scared about one main thing. What if I teach this person and 6 months later they turn and go and open up shop? They take all my ideas, they take all of my planning, and they run their own business. And now I have a competition with somebody who hasn't even remotely had to learn and trial and error that I've gone through. It's a very realistic concern. So the first thing, as you can see there, is when you train ahead and you're trying to prepare for smooth transitions, the first thing you definitely want to have in place is a non-compete clause. Now, there's a caveat to non-compete clauses that I don't think enough attorneys talk about. Courts want them to be fair, and they really need to be. They have to be, or they won't be enforced. So I've seen some pretty just blatantly inappropriate non-compete clauses. There's no way a judge would enforce that. You're basically starving the person out of business. So they have to be limited. And what I mean by that is, if you say that you're in a specific type of industry and this person comes to work for you, you've had them sign a non-compete clause, that basically means that they can't start a business for either a certain period of years within a certain radius of the business that you operate in that would be identical to what you do. They can't compete with you. That's the whole point of the non-compete clause, which is still very valid. Courts do uphold that because they understand the value of trade secrets. They understand the value that you've put in, but they also really value people working. And so you need to make sure that that non-compete clause says things like maybe a 50-mile radius, maybe a 25-mile radius. If you have a 200-mile radius, you're trying to take over the whole state, but you only actually realistically operate within 25 miles, that's malicious. That's going too far. And so you can't put that in your non-compete clause and think that it will be enforced. Same with the time. You can't say 5 years. They can never work in this industry again. The longest I've seen that's really been upheld is often 2 years is the most common. So 2 years with a minimized specific parameter, like geographic location of where they could operate. Non-compete clauses they can get messy, but those are some tips for how you can make yours be more successful and fair. You want your employee to feel safe to work for you, and there's nothing that makes you more afraid as an employee than being hit with a non-compete clause that seems crippling, seems like you can't work, you have to move states and go away. So you want to make sure that you're being fair and reasonable. The other thing you can do for preparing ahead of time, a long time ago, almost 10 years ago at this point, I taught high school students, 9th through 12th grade business. And during that time, I don't know if it was by for what reason. I've never been a cheerleader. I had no idea what I was doing, but I got asked to be the cheer coach for our high school. And you can imagine how, not knowing anything, how hard that would be. And when I took over, the last person didn't know anything either. So there was nothing that I walked into thinking I'm just going to learn how to drill them during kicks and prepare for nationals and just the stuff, just do cheers and chants. But there was so much more behind the scenes. And so I decided to journal all of it. After I started realizing, in August, we had to make baskets for the other team. I'd never heard of such a thing. But who was responsible for the basket? Apparently it was the cheer coach. So I bought so many baskets just to give them away to some other team we were playing that night. Or we had to plan the pep rallies. That was on us. We had to make the whole thing and contact everyone. We had to order the buses for when we went to nationals. We had to get our camp set up and register for all of that. Uniforms. There's just so many things that went far beyond just putting them through some workouts. And so as I journaled, I realized, wow, I have made like a foolproof plan, like silver platter program for the next person. So after I was done with my years as cheer coach, the next person came in, next 3 people actually. So it tells you right there, I'm either super good that they needed 3 people to replace me, or I'm a chump that I did it for so long by myself. But anyway, I gave them this journal and they were able to see everything coming before it hit their face. And that makes a huge difference in your organization and what you're trying to do to make sure that nothing falls through the cracks. It's going to be stressful enough to run a business. So if there's anything you can do ahead of time that would help that transition to prepare, go ahead and do it. Start writing things down. What do you do? When are your key months that make things different? Your key contacts. If there's a specific pattern that you have to do, maybe you're a pool company and you check the water, and so you got to train someone on how to check the water. Video yourself. How do you do that? How do you take your measurements? How do you backwash a filter? Those type of things, being able to do it ahead of time so that when the right person comes and you feel safe to share that information with them, it will be already ready for them. And so they can sort of learn it as they go. The other thing is you can wait until you're good and gone before you share it. And so now you don't have to worry about them taking advantage of you, because why would they? You're out of the picture. They have a whole company right here with the manual, a video guidance. So I just think it's understandable as entrepreneurs. Every time I hear somebody say business is impersonal, I realize you've never been in business before, because business is very personal, especially when you build it, especially when it's yours. And so I can understand the apprehension of succession planning, because you can't imagine doing all this work just to hand it over to somebody else. And the fear of trying to do that ahead of time, which is really the right thing to do. It's the smoothest process, is to be able to train on the job with someone, but you're nervous. You're downright scared. Somebody is going to take your ideas, take all of your contacts, take your secret sauce and go and do it for themselves. And so that's very understandable fears. And I hope that those are 2 methods that the videoing, journaling, I don't ever hear any other attorney advise. So it's definitely not legal advice, but it's my advice. And I think that it can be very beneficial for your company and easy for you. I think it creates a very personal connection when you do that. The next thing I was going to share with you, and we're about to wrap up. This is just an example clause in one of my operations agreements. So I drafted this. I changed the name of the member for confidentiality, but basically a lot of times people will have things like dissolution clauses in operation agreements, but they will not name if something happens in death or incapacitation. And just so you know, it can be this simple. You can literally say, in the event of unexpected forfeiture of members' rights, such as death or incapacitation of member, the member confers all member rights and appoints, I said Bob Baker, as the sole member of the company. And right then and there, you have it in your agreement of your business of exactly how it will operate moving forward if such things were to occur. And so that little one sentence provides you so much protection. I encourage you to make sure that you have drafted that, you've written that into your operations agreement, you've thought about it. I always tell people, if you can't make a decision right now, you just can't think of anybody. Imagine if the court were supposed to do it. Could you make a better decision than the court could make for your business? And most of the time, yeah, I would think for sure you could at least make a better decision than what could be made for you. So definitely take time, really think about it, because it's very important. And that is all I have for you guys today. So again, I'm Tristan Hunkin, and Right Limit Investments is, I don't think I mentioned it in the beginning, but it's a nonprofit that I chair with several other professionals for entrepreneurs who are seeking to launch their business. And so we help with registration, state registration, getting them started, marketing, general business support. So if you or anyone you know might be interested in that, please feel free to visit that website. And then I operate Hunkin Law for business planning and estate planning. Thank you, guys.
Thank you, Tristan. If anybody has any questions for Tristan, please feel free to put them into the chat or the Q&A. We do have just a couple of minutes for questions. Not seeing any questions come through. Tristan, I have to say, I love the story about you being a cheer coach. I bet that even with no prior cheer experience, you were awesome at that. And it really helped me to understand the value of thinking ahead and understanding that somebody else is going to come behind you inevitably. There will be things that happen after we are done with what we're doing. And the more thought and time and prep that we can put into anticipating that, the better off we're going to be in the current time, and the better off they're going to be sort of preserving our investment in the future. So thank you so very much for sharing this information with us. And I encourage those who are watching, if you have further questions for Tristan, please contact her at the contact information on this final slide. Thank you again for being here, Tristan.
Thank you so much.
All right, take care. Bye-bye.